Hello, everyone, and welcome back to Podcast ABNR. Today, we are unpacking an important topic in Indonesian competition law, which is vertical restraints. Now, you might be wondering, what exactly are vertical restraints and how do they impact businesses and also us as customers, for example? And what does Indonesian law say about them as well? But we are very fortunate today because we have as a very special guest, which is our foreign counsel, Gustaaf Reerink, and also our associate, Mbak Ilma, which will accompany us to talk more about the topic that we'll be discussing very soon. So welcome to Podcast ABNR. But before we start, I think our listeners have to know more about our speakers. So maybe, Gustaaf, you want to introduce yourself to the audience?
Sure, Reza, and thanks for having us. My name is Gustaaf Reerink. I've been foreign counsel with ABNR for over 12 years now. I've been involved in mostly mergers and acquisitions, corporate related work, and also antitrust, the topic that we will discuss today.
Thank you, Gustaaf.
Thank you, Reza. Hello, my name is Ilma Sulistyani, and you can call me Ilma. I've been working in ABNR since 2018, so it has been almost 7 years now. I'm mainly working in corporate competition and also antitrust team, particularly on merger filing and also compliance advisory. I also work on several due diligence and corporate matters for acquisitions of companies in across business sectors.
Thank you so much, Mbak Ilma. So maybe, Gustaaf, you want to give us a brief introduction to the team as well?
Yeah, well, the antitrust and competition team is quite large. We have around 10 associates and several partners are also involved in competition work. And we basically do three things. So first of all, we assist clients with transactions. We advise clients whether they need to make a merger filing in Indonesia. This is actually the main focus of our practice because indeed, under Indonesian competition law, even foreign-to-foreign transactions may need to be notified in Indonesia. So that means although the purchaser or the seller is foreign and also the target is foreign, you may still need to make a filing. So very often we advise on that, and if indeed a filing is required, we assist the client also in making the filing. Secondly, we do quite a bit of compliance work. You see that the Indonesian competition authority is getting more active in enforcing the rules, and also clients becoming more aware of the risk of not being compliant with the Indonesian competition law. So we advise them on how to navigate the, I would say, quite complicated legal structure and to avoid that they get penalized. And finally, we also involved in litigation. So sometimes indeed the KPPU initiates an investigation and we assist the client then with the investigation. Yeah.
Thank you, Gustaaf. So before we delve more into the discussion topic, I think it's best for our listeners to know more about vertical restraints. What is it exactly?
Okay, so basically in simple terms, unlike horizontal restraints which involve competitors, vertical restraints are restrictions imposed between business undertakings at different level of supply or productions. So for example, manufacturer and also retailers and distributors. Yeah.
I think I'm getting the idea of vertical restraint itself, but I'm also curious about the regulatory framework under Indonesian law. Maybe, Gustaaf, you want to give me a brief explanation about that.
Yeah, vertical restraints are regulated under the Indonesian competition law. So that is law number 5, 1999. And there are also several guidelines which are published by the KPPU on the specific prohibitions. Now, I must say, though, that some prohibitions do not have guidelines yet. So there you see that there's a bit of a legal gap, and it's not always entirely clear how the Indonesian Competition Authority, so the KPPU, would apply the prohibitions.
So I'm guessing the concept of vertical restraint itself, I think it's quite broad. However, what types of vertical restraints that are covered under our law?
Well, so vertical restraints, interestingly, are not specifically defined what it is basically in the Indonesian competition law, but there are several prohibitions that relate to these vertical relationships. I think the most important to mention are price discrimination, secondly, resale price maintenance, exclusive dealing and tying agreements, vertical integration, and also tying agreements associated with special discounts and exclusive dealing associated with special discounts. So under the Indonesian competition law, vertical restraints can basically in the form of prohibited agreements or prohibited conduct. This is an important distinction within the law. Unfortunately, we cannot cover everything during this session, but to give you some examples, what is prohibited is an agreement which causes one buyer to pay a price that is different from the price that must be paid by another buyer for the same goods or services. So this is price discrimination, which is regulated under Article 6. What's also prohibited is the agreement that an undertaking prohibits an undertaking to resell or resupply certain products or services at a price that is lower than the agreed price. This is resale price maintenance or RPM, which is prohibited under Article 8. Then we also have the agreement that contains a condition that the recipient party of goods or services will only resupply or not resupply certain goods and services to a certain party or to a certain place. So this is also a matter of exclusive dealing, which is regulated under 15A. And finally, what we would also like to discuss is basically tying agreements. So basically an agreement which contains a condition that the recipient party of certain goods or services must purchase other goods or services from the supplier business. Tying agreement, which may also be prohibited.
I see. Thank you, Gustaaf. But in context of the agreement itself, are they always have to be informal written agreement?
If we refer to the Indonesian's competition law, basically it provides a definitions that an agreement as an actions of one or more undertakings to bind themselves to one or more other undertakings under any name, whether or not in writing or in non-written form. So in order to engage in violations of competition law, in terms of vertical restraints, it is not necessary for there to be a formal written agreement. So we see that in the past, for example, in one of the KPPU cases on bottled water in 2016, in which a principal and distributor were fined for allegedly violating special discount prohibitions. Although some of the commitments were not laid down in a formal written agreement, but those collaborations, finally the KPPU decided that those collaborations are amounted to concerted actions. So, and we also see that in other cases, the KPPU also determined that there was violations of vertical restraint prohibitions, despite there being no written agreement, and it was in 2003, if I'm not mistaken.
But are all vertical restraints in forms of like a written agreement, are they all like automatically prohibited?
We would say no, because not all vertical restraints in the form of agreements are automatically prohibited under the Indonesian competition law. We see that the KPPU applies. We call it as a rule of reason. It is an approach to most vertical agreements, meaning that the KPPU will assess on a case-by-case basis and to determine the effects on the competitions. So some anti-competitive agreements are prohibited irrespective of their effect on competitions. We call it per se. But based on our observations, even if in such cases, the KPPU will also delve into more detail on the agreement or conduct itself to consider whether certain factors are applicable, for example, market control or dominant positions. And we want to also note that as a part of rule of reason approach, the KPPU will also consider an undertaking market share. So some prohibitions can only be violated if an undertaking has market power or dominant positions.
There are two terms that I think is very interesting, which is market power and also dominant positions. What are those two?
Maybe Gustaaf will add.
Yeah, so market power and dominant position are very important concepts in the Indonesian competition law. Because indeed, when an undertaking has a certain, usually market share, there's a stricter application of certain competition rules. So if you talk about market power, it basically means that you are, as an undertaking, are able to increase the prices above competition level while still making a profit. And usually, indeed, it depends on market share. So if you have, for instance, 10% market share in the relevant market, or it could also be that certain special factors apply. So if you talk about vertical relationships, of course, you could, for instance, have market power as an undertaking because you have a certain distribution chain. And that gives you a certain power to determine price, so without basically suppliers or customers in this case walking away. Then there's also dominant position. This is a bit of a higher standard where you have a dominant position if you have 50% market share or more alone, or together with one or two other undertakings, you have a market share of 75% or more in the relevant markets.
Okay, no, I think the concept is highly economic and I think rather quite complex as well. Even for lawyers, for instance, for myself, I think it's a complex thing to grasp upon. What do you think, Gustaaf?
Yeah, I fully agree, Reza, and that's the thing. I mean, Indonesian competition law is complicated, and also indeed because it relates to economic aspects, market, commercial. And the law itself, as I mentioned before, because not always the guidelines have been introduced, so there could also be some legal gaps. So that's always the challenge for us, basically, that we try to advise clients in the most commercial way. We know that some of these rules can really affect their business if you would have to comply with it very strictly. So we need to advise in a common sense way.
Agree. Now, going back to our earlier explanation, I think I'm particularly interested in exclusive dealing because we often see this in exclusive distribution agreements in practice, right? So could you elaborate more on that, please?
So yes, as Gustaaf briefly mentioned before, exclusive dealing is in principle an agreement with another undertaking which contains a conditions that the recipient party of goods or services will only resupply or not resupply the goods or services to a certain party at a certain place. Although strictly based on the wording of the provisions of this article, exclusive dealing is governed under the per se rule, meaning regardless whether the agreement or conduct will result in anti-competitive effect, it will be regarded as violations under the Indonesian competition law. But in this case, the KPPU has issued a guideline on Article 15 of the Indonesian competition law on close agreement to help us in interpreting the Article 15 of this law. And if we refer to the guidelines, the guidelines provide some kind of explanations in which exclusive agreements are prohibited if certain conditions are met. For example, they substantially or potentially reduce the volume of the trade, or exclusive agreements have been entered into by the undertakings that have market power, which has been explained by Gustaaf before, or the market power can increase due to the exclusive arrangements. And if we see the guidelines also acknowledge that exclusive agreement or arrangement may also have positive impacts on competitions. These positive impacts can be in the form of an increase of specializations between the producer and distributors, resulting in an increase in economics of scale for each party and a reductions in uncertainty in the distribution process. And it can be in the form of reductions in searching transactions and monitoring costs, resulting in more efficiency, and another type of reductions which is positive for competitions. So if we see that the close agreement guidelines provide both negative and also positive impacts on competitions, So far, we have observed that distribution system exclusive dealing is more likely to be lawful where it relates to high technology, for example, like motor vehicle or electronic vehicle. And we would say that it is common in Indonesia to create some kind of selective distribution network or exclusive dealing in this case. Maybe partly because these products require some kind of after-sale service. So as far as we are aware, the KPPU has not strongly acted against this kind of arrangement. Apparently because they also acknowledge the positive impact that have been explained in the guidelines.
Now that's very interesting, but I'm also curious to know from a consumer's perspective, if we want to purchase a product, let's say, and if we reach out to the seller, but the seller does not want to or refuse our request, for instance, due to an exclusive agreement restricting sales to a specific party or locations, for example, would this be considered as anti-competitive under Indonesian law?
Yeah, now, Reza, that's an interesting point you raise, because it's very common that in distribution agreements, basically there's a restriction that the distributor is not allowed to sell the products outside its territory. And so this is an exclusive distribution agreement. There you have to distinguish between passive and active sales. So you can restrict basically a distributor to actively sell to customers outside his territory, or passively, where basically customers would approach the distributor and ask for the product. Often passive sales in a lot of jurisdictions is actually allowed, but active sales not. Unfortunately, in Indonesia, it's not very clear. The Indonesian competition law and also the guidelines do not provide clarity on this matter, whether also active or at least passive sales are prohibited. However, there's one case where undertaking was imposed a penalty of 1 billion rupiah, and this was indeed a restriction of both active and passive sales.
Now, I think in this conversation, throughout our discussion, we have discussed a lot of prohibitions under Indonesian competition law. But are there any exemptions for certain conditions for or agreements, for instance?
Yeah, there are. There's actually Article 50 of the Indonesian competition law, which exempts certain prohibitions for certain agreements. Maybe an important example in this case is agency agreements. So this is also a vertical relationship, basically an agent, but the prohibitions in principle do not apply to agency agreements. Now there's a bit of a confusion about this exemption, because it doesn't necessarily mean that you can just do anything with an agency agreement. The KPPU makes clear in the guidelines that even if it's an agency agreement that violates certain prohibitions, that they could, under certain conditions, still initiate an investigation. You also need to be careful that, of course, the label covers the agreement. So you cannot just say, oh, this is an agency agreement, while in fact it's a distribution agreement, and say, oh, we're exempted. So the KPPU will really check if an agency agreement really is about an agent, which means it is someone who acts for a principal and not as like a distributor who's acting for its own risk and account, because in that case it's a distribution agreement, and distribution agreements are not exempted from the prohibitions under the Indonesian competition law.
Thank you so much, Gustaaf. I think it's been a very interesting session to talk about this particular topic. As we wrap up today's discussion on vertical restraints in Indonesian competitive law, we hope this session has provided valuable insights, of course, into how these regulations impact businesses as well as consumers. And of course, massive thanks to our speakers, Gustaaf and also Mbak Ilma, for sharing their expertise and also experiences in this complex yet crucial area of law. And of course, thank you to our audience as well for your engagement. And we hope to see you again really soon in our next episode. And we hope you have a good day, everyone. Thank you.